Okay, if everyone could take their seat. Good evening, everybody. We're going to get started. We have a lot to get through and a great show in store for you guys tonight. My name is Nick Borton, and for the past 6 years, I have had the great honor of serving as the chair of the board of the Office of the Appellate Defender. And it is my pleasure to welcome you to our 32nd annual First Monday in October. We are going to do everything we can to stay on schedule tonight. In past years, we've had to contend with the Major League Baseball playoffs. This year, the schedule makers were kind enough to give the Yankees an off day on First Monday. The Mets were kind enough to arrange that all by themselves. Sorry, Mets fans. So as many of you have heard me say at this event in the past, OAD is a crown jewel in the nonprofit world. It provides the highest caliber legal representation and holistic support to its clients, and it does it on a shoestring budget. And the way we make that happen is tonight with First Monday. First Monday is critical to our annual budget and to ensuring that OAD has the means to achieve its very important mission. We also think it's the most fun and entertaining fundraiser in New York City. We have an all-star lineup for tonight's program. Our advocates and recipients of the Gould Award for Outstanding Advocacy, Katya Jestin at Jenner & Block, and Anjan Sahni of WilmerHale. Our Chief Justice and recipient of the Counsel for Justice Award is Cari Gallman of Bristol-Myers Squibb. And our mock Supreme Court Justices, Deborah Colson, Tenny Garagos, Victor Ho, Ed Imperator, Michelle Levin, David Massey, Benjamin Naftalis, and Avi Weitzman. And we are also so proud tonight to be presenting the Beacon of Hope Award to Dexter Murray and the OAD Gideon Award to Freshfields. I want to thank everyone who has participated in First Monday. This event only works because of the willingness of so many people who have very busy schedules and yet still find the time to dedicate their time and talent to our cause tonight. We ask a lot of everyone who participates, especially our Gould Award winners who have been preparing for this for weeks. And we are so appreciative of their and everyone's time, talent, and energy. I also want to give a special thanks to our corporate sponsor, FTI Consulting. FTI is known, no doubt, to everyone in this room as one of the preeminent global investigation and consulting firms in the world. Many of you have probably worked with them and know the exceptional level of talent and commitment at FTI, but they have also been a stalwart supporter of OAD and First Monday for many years, and we are so grateful for their generosity in sponsoring tonight's event. And I want to thank all of you who attended tonight and for your generous support of OAD. So, without further ado, I'm going to turn it over to OAD's amazing president and attorney in charge, Caprice Jennerson, and she's going to tell you more about what it is you're supporting tonight, the incredible work that OAD does every day.
Good evening and welcome to OAD's First Monday in October Gala and Mock Supreme Court argument. I really want to thank you all for joining us tonight. The room is much fuller every single year, and I appreciate that. As Nick said, I want to make sure to give a special thanks to our presenting sponsor, FTI, but I want to also make sure that I thank our host committee. So a segment of our board spend 6 months on Zoom calls, emails, and telephone calls in making sure that this event happens in the way that it does, and I want to make sure to thank each of them. And I also want to make sure that I thank the entire board of directors who lean into the responsibility of partnering with OAD, not just for this event, but for everything where governance matters. In addition to our presenting sponsor, FTI, I want to make sure that I thank Electronic Paralegal, who prepares the lovely journals that you found on your seats, and they do so for us free of charge. So we certainly appreciate that. Last but not least, I want to make sure to thank the Jones Day team who worked alongside one of OAD's supervising attorneys in preparing the bench brief that the advocates and the bench will use in preparing and giving oral argument tonight. And the special thanks for me is to acknowledge my staff, the attorneys, the paralegals, the client advocates, and administrative personnel who work tirelessly to give life to our client-centered mission and values. And so wherever you are in the room, I want OAD staff to stand and be recognized. And they're everywhere. Today, the United States Supreme Court convenes for the start of its October term to tackle fundamental questions about presidential power, voting rights, and even the First Amendment. So while that's all happening in Washington, here in New York, I have the privilege of working alongside brilliant minds at OAD who fight against prosecutorial overreach, misconduct, wrongful convictions, excessive sentencing, and legal errors that deprive individuals of their liberty. And whether we are understaffed or under-resourced in any way, we show up for our clients with skill, compassion, and heart. Every brief that we file, every appeal that we argue, every mitigation report that we draft, it is a reminder that justice is for everyone. At OAD, we believe that human beings are not disposable, and the criminal legal system must be fair, and it must be just. Your generosity allows us to keep fighting. We are deeply grateful to each and every one of you for partnering with us over the years. We thank you. So to begin our program this evening, I have the honor of presenting our first two awards. The first is the Gideon Award. This award honors a law firm that has shown exceptional commitment to indigent appellate defense through OAD's Volunteer Appellate Defender Program. Through this program, attorneys at participating law firms get valuable hands-on experience in all aspects of criminal appeals, from issue selection to oral argument, all under the supervision of an OAD supervising attorney. Most importantly, OAD's clients receive the support of a dedicated associate or partner through the program. Freshfields has collaborated with OAD on at least 18 cases, dating back to 2013. Currently, Freshfields is working on a really important case for us, a case that we started litigating probably 20 years ago. One of our clients was sentenced to life without parole at the age of 19 and has now served about 29 years in custody. And OAD, Freshfield has partnered with us to fight against the unjustly long sentence of that client. And today we are proud to present the 8th Gideon Award to Freshfields. And the award will be accepted by Christian Vandergeest.
Thank you very much, and thank you for that introduction. It's an honor to receive this award, but I think everyone in this room would agree that the real honor and the real privilege is to work alongside OAD. I took my first OAD case many years ago as a junior associate. I thought I was signing up for a quick appeal, a good experience, and then I learned that none of these cases are quick. As we just heard, one of the cases Freshfields is working on has been going for 29 years. The one I signed up for has now been going for 6. And we just filed a habeas petition this summer in the Southern District. In that time, I've had plenty of opportunity to watch OAD at work. I've seen firsthand the amazing opportunities that OAD is providing to the lawyers and to the associates at Freshfields. We have dozens of young lawyers who have benefited from OAD's mentorship, from OAD's teaching. And just as importantly, working with OAD has given us the opportunity to advance justice for those who need it the most. We're immensely grateful for the opportunity to work with you, for the opportunities you provide to our young lawyers to handle important cases, stand up in court. So thank you. We're proud of the work we do with you, and we're looking forward to doing much more together. Thank you very much.
Our next award is the Beacon of Hope, which honors a former client who, despite extraordinary challenges, demonstrates resilience and strength. Tonight, we will honor Dexter Murray. Mr. Murray spent 31 months on Rikers Island awaiting trial, all the while maintaining he was innocent of the charges against him. By the time he got to trial, he had lost faith in the system, in his lawyer, and the court in general, and so he decided to represent himself. In doing so, he raised a spot-on Batson challenge when the prosecutor struck nearly all of the black jurors. Although he lost at trial, his appeal, handled by Adam Murphy, who was an OAD staff attorney at the time, was won on that very issue. And what has impressed me most in the conversations I've had with Mr. Murray over the past several weeks is just how positive his outlook is. After all that he has endured, he just is always so positive and so full of hope. And in the face of injustice, he's turned to advocacy. He's written op-eds, he's spoken on national platforms, he even mentors alongside his former attorney at NYU. His strength and determination are inspirational, and I'd like for you to stand and recognize and celebrate Dexter Murray.
Thank you for that introduction. It was very special. Considering that I never received anything in life but probably hell. So this is like a great surprise. And I'm speechless to say the least. The last couple of weeks I've been in contact with Ms. Jennings, and it's been like a whirlwind because I was like beyond excited to be considered even for saving my own life, because that's what this was really about for me. I had to save my life. So I decided that I wasn't going to allow no one to fall on my sword. I would rather fall on my own sword. I felt as though if that was going to be the case, that I would have to represent myself. If there was going to be consequences, I would pay. This lawyer's going home tomorrow. I'm going upstate, Attica, Elmira, Caxton. I couldn't deal with that reality. Again, because as a youth, I found myself caught up in that lifestyle that resulted in me having a past. And when you have a past and you get caught up in the judicial system, that's your dying swan song. Because when you come there, you got a record, then they could use that against you. So with me having experience like that, while I was incarcerated as a young individual, I decided that I wanted to be able to champion my own cause. So I started studying them law books. I read them like incessantly. I have a bad habit even to today. I'm like, I have insomnia as a result of staying up, because that's the most time, quietness is very late at night, 2, 3 o'clock in the morning. I was reading all of those different tomes, and then I decided that, you know what, this is something I would like to do, but when you got a felony, you can't do that no more. That's it. That's the 13th Amendment, right? Once you get convicted of a crime, that's it. You can't represent, unless you're the president, unless you're Donald Trump. So I just had to get that one in, So with, I want to thank my family. I want to thank the OAD. I want to thank, because OAD been in my life, unfortunately, and I guess fortunately, since I was a kid. I remember them. They come to court and they champion your cause to try to get individuals that adolescents that had some brush with the law. They try to get them alternative to incarceration programs. They've been doing this since I was a kid. And I was just sitting here saying, OAD been around since I was like 17, 18. I'm 59. So I'm grateful to OAD. I learned a lot, and blessed to have received this award. I just want to thank Adam for being instrumental in deciding that the Batson issue was the best issue to address to go with that. Because I had a couple of issues on appeal, but I knew that one was like very significant. It stuck out in my mind. I said, you know what? This lawyer, Melanie Soberall, she excluded all the blacks. And I was like, Your Honor, something is wrong with this. I said, I object to that. So they was like, he object, and then the standby counsel was like, you know what? I didn't tell him that, Your Honor. And I was like, damn, this is a big deal that he would tell me to object, and he didn't tell me. But I just knew that every time I look, I said, all the African Americans is getting excluded off this jury. I'm never going to get a jury of my peers. I said, you know what? Your Honor, I object. And then, so the judge said, all right, I don't know if this is a good time to bring up this objection, because now it was a question as whether or not I brought it up in a timely fashion. And I was like, well, I'm going to bring up an objection to a voir dire picking a juror during the time that it's going on. So the jurors, when they seen that, they was like, you don't want us? And I felt bad because I didn't know what to do. I was like, and then he said, yo, go out. The judge said, excuse juror. So I said, I'm in trouble now. So to make a long story short, this is the end result, and I'm grateful for that. So thank you to my family, to everyone.
Let's see if this works. So tonight you will hear oral argument from two distinguished litigators, Katya Jestin and Anjan Sahni, before our esteemed mock Supreme Court. The case you will hear is Hamm versus Smith. The respondent in the case has been sentenced to death in Alabama. Following the respondent's death sentence, the United States Supreme Court held in the case of Atkins versus Virginia that death is not a suitable punishment for an intellectually disabled person. The 11th Circuit vacated the death sentence and, in its opinion, discussed its holistic approach to assessing the respondent's cumulative IQ scores. This esteemed court will consider how to weigh or analyze cumulative IQ scores in determining whether a person is intellectually disabled and therefore ineligible for the death penalty. This issue certainly goes to the very heart of fairness and humanity in our criminal legal system, and we are honored to bring it to life here tonight. So just a few housekeeping things so you know. The rest of the program will go forward without intermission. After the oral argument, you will hear from OAD's board chair, Nick Borton, and board members Joanna Hendon and David Gopstein, who will present the Gould Awards for Oral Advocacy and the Counsel for Justice Award. And then we will observe the deliberations of the mock Supreme Court. I'd ask you to please take a moment and make sure that your cell phones are either silenced or turned off. And now I invite our court crier, Myrna Felder, to open this court's session for the first Monday in October 2025.
Please rise. The justices of the mock Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the mock Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God bless the United States and this honorable court. Please be seated.
The court will hear argument in number 24872, Hamm versus Smith. Ms. Jestin, we will hear from you first.
Thank you, Madam Chief Justice. May it please the court. In November of 1997, right before the Thanksgiving holiday, Joseph Clifton Smith brutally murdered a man by beating him to death with a hammer and a saw. Why? Because Mr. Smith wanted to steal the victim's shoes and $140 in cash. A jury in the state of Alabama convicted Mr. Smith of capital murder and sentenced him to death for this brutal crime of violence. Mr. Smith now seeks to avoid the death penalty under Atkins versus Virginia as applied under Alabama law. He seeks exemption from capital punishment under the Eighth Amendment due to a claimed intellectual disability. Mr. Smith did not meet his burden of proof under Alabama law and is not entitled to Atkins relief, and the 11th Circuit erred in granting it. This court should uphold principles of federalism and protect the state of Alabama as it works to enforce its laws. Over 4 decades, Mr. Smith has taken 5 full-scale IQ tests with remarkably consistent results. His average IQ score is 74.6. Under sound statistical analysis, accounting for the standard error of measurement in both directions, there is a 95% confidence interval that Mr. Smith's true IQ falls between 72 and 77, entirely above the 70 IQ threshold that would satisfy the first Atkins prong.
Counselor, there's evidence in the record that at the age of 28, Mr. Smith was barely literate, that he performed math at the kindergarten level, that he struggled with social interactions, and that he was emotionally dysfunctional. So does that, the approach that you're advocating, tell courts that they should ignore all of that?
So thank you, Justice Colson. The Atkins test as applied under Alabama law is a conjunctive test, and defendants seeking relief under Atkins are required to show each prong by a preponderance of the evidence and their independent requirements. So what you've described would go to the second prong of adapted behavioral deficits, but Mr. Smith was unable to satisfy the first prong, which is an independent requirement.
Step, Counselor, because on a numerical threshold, claimant didn't meet your standard?
It's not my standard, Your Honor. It is the state of Alabama's law. Under Atkins versus Virginia, this court delegated the implementation of the Atkins test to the states. And Alabama has set forth a very carefully calibrated statutory construction under which the defendant seeking relief must show by a preponderance each separate prong independently.
Understood, but you're not challenging our ruling in Atkins, correct? So you agree with me that death sentences for those who are intellectually disabled constitute cruel and unusual punishment, correct?
Correct. But also under Atkins, Your Honor, it delegated the implementation of the test to the states because there is no national consensus. And there are a number of things we can all think about that are delegated to the states and are constitutional. And the Alabama structure is very common. It is used by a multitude of states across the country, and it requires a defendant to show each independent requirement by a preponderance of the evidence, and Mr. Smith failed to do that.
Didn't the district court here, as affirmed by the 11th Circuit, do exactly what we've asked it to do, which is to weigh all of the evidence at a hearing in order to take a holistic approach as to Mr. Smith and his IQ?
So, Your Honor, it is not a holistic approach that is required under the law as applied in Alabama. Alabama requires that each prong of the Atkins test be satisfied independently. It is not a holistic balancing approach that weighs the factors with one another. It is an independent requirement. And the evidence in the district court was not contested. It was not contested. So we are dealing with the 11th Circuit essentially rewriting Alabama law. In spite of the evidence that was presented at the district court, instead of operating within the constitutional framework as established by this court and implemented by statute in the state of Alabama, the 11th Circuit sidestepped constitutional requirements, applied its own made-up standard that the first prong of Atkins is satisfied by the mere possibility of an IQ under 70. That is not the law.
Counselor, the whole point of Atkins was to ensure that people who are truly intellectually disabled are not executed. Does a rigid cutoff undermine that by turning what should be an individualized judgment into a mechanical one?
Your Honor, there was not a rigid cutoff in this particular case. Mr. Smith received 5 full-scale IQ tests over the course of 4 decades. And so applying a statistical analysis to that wide range of tests over a long period of time actually creates a more reliable true average of 72 to 77, and that is why Mr. Smith did not meet his burden.
The death penalty is the ultimate power in the criminal justice system. It is irreversible, and making a mistake in this regard is worse than in one direction than it is in the other. District courts have the ability to observe the offender, to see how they react in court, to see what their intellectual capacity is. Why not let the district court have the discretion to review all of the evidence instead of creating some sort of litmus test based on an IQ? Isn't that the opposite of what Atkins asks us to do?
Respectfully, Your Honor, it is not. In Atkins, you all delegated the implementation of the test to the states. And in Alabama, each prong of the Atkins test is required to be established by a preponderance of the evidence. And the 11th Circuit essentially rewrote Alabama law by shifting the burden, inverting the burden, and putting the burden on the state to prove a negative.
And where's the cutoff? If the statistical average was 70.5 to 72 of all the average tests, would you say that you don't move on to the second prong of the Alabama test?
Well, Your Honor, I think that is obviously a different case with a different set of facts, and all I can comment on is the set of facts here that pertain to Mr. Smith.
And so in response to my question, 70.5 to 72 as the range statistically for the IQ tests, would Alabama law authorize the district court to evaluate or move on to the second stage?
Your Honor, I think it depends on when those IQ tests were taken, and I think it also depends on a statistical analysis being applied to the IQ tests that pertain to that particular hypothetical. But that's not this case. In this case, Mr. Smith had 5 full-scale IQ tests over the course of 40 years. 40 years. And factoring in the standard error of measurement, as this court requires states to do, Alabama concluded by a 95% confidence interval that his true average IQ is between 72 and 77.
Counselor, doesn't that automatically, you've said now twice that there's a 95% confidence interval. So would you have us overturn the district court, overturn the 11th Circuit on a 5% chance that he might be in the other, that his IQ might have been lower?
Your Honor, those policy decisions are really the province of state legislatures. State legislatures are elected to represent their constituents, and they passed a law in the state of Alabama that requires a line drawing. That's what legislators do. And so those policy considerations must be considered at that level, and the courts must apply them faithfully. And in this case, Alabama requires that the defendant prove the 3 prongs by a preponderance of the evidence and their independent requirements. The 11th Circuit cannot rewrite state law. That is judicial activism, and it is not constitutional.
Counselor, where in this law does it say to average the IQ scores? Because given that Alabama focuses on the developmental period, is it reasonable to give more weight to the IQ scores that are closer to the developmental period, which in this case are significantly lower?
Actually, Your Honor, I don't think that that's actually the way that the medical experts evaluate the IQ scores. I think they look at the full range, and in this case, they were remarkably consistent. And there was no challenge to the expertise that was presented during the hearing at the district court level.
But in this case, we're faced with a lengthy evidentiary record before the district court, where the district court evaluated the expert opinion and nevertheless concluded that the preponderance of evidence had been met in this case. Isn't that finding entitled to deference?
We're here to evaluate the 11th Circuit decision to vacate the state's decision not to provide Atkins release to this defendant. And the 11th Circuit explicitly inverted the burden. The 11th Circuit said that there was a mere possibility that his IQ was below 70, and therefore the court was to proceed to evaluate the remaining Atkins factors. And that is not the law in the state of Alabama.
Your Honor, Counselor, excuse me, I'm just a mock justice, so I sometimes forget my role.
People make that mistake all the time.
Yes. State legislatures, if they define intellectual disability differently from the medical community, doesn't that invite the very arbitrariness that Atkins condemned?
I don't think that there's an argument here that the way that Alabama treated the evaluation of his IQ scores or the quality of the IQ scores themselves were not medically acceptable to both the state of Alabama and to Mr. Smith's counsel. There was no dispute over the quality of the evidence that was presented. This is a question of who bears the burden. And under Alabama law, Mr. Smith bears the burden, and he did not meet it.
I guess what I'm asking is why the constitutional protection against cruel and unusual punishment should vary state by state.
Well, this court in Atkins versus Virginia expressed the test, the three-prong conjunctive test, and stated that they were going to allow the states to implement the test as they saw fit, as long as it was on the constitutional side of the line, based on the idiosyncratic views of particular states. There are many laws like that. For example, New York has shield laws that protect telehealth abortion providers. California has idiosyncratic environmental laws that address the constituents' desires in California. That is not an unusual approach to take, and it's the approach that this court expressly took in Atkins versus Virginia.
Counselor, you agree, do you not, that there is built into these IQ tests and these quota numbers and thresholds that you propound are filled with error and judgment? Do you agree with that, do you not?
I'm not a medical expert, Your Honor. I will say that in this particular case, Mr. Smith's own expert testified as to the reliability of the tests that were provided to Mr. Smith, and the fact that they were provided over such a long span of time also elevates their reliability.
I thought it also could amplify the mistakes. You're not aware of the Flynn factor, you're not. Over time, generations, IQ increase perhaps as much as 1 point over 3 years, correct?
So I don't think the Flynn effect is really applicable to this case, where two of his highest IQ scores were the most recent IQ scores taken in time.
But a span of 40 years, correct?
Yes.
So every year that could be his IQ tests, as they are reflected, are inflated, correct? There's uncertainty. You cannot determine to a degree of mathematical certainty, correct?
But that is why the margins of error are included in the statistical analysis that's provided and applied to the 5 IQ scores at issue here. So when these IQ scores were analyzed, the margins of error, or the standard error of measurement, going in both directions was incorporated in that analysis. And that's why the true average IQ score has such a high percentage of confidence in the confidence interval under the statistical analysis of 72 to 77.
You say true as if there's objective truth, but you, in your papers below, said the Fifth Circuit had it right and analyzed our factors under Atkins correctly. But if I'm not mistaken, the Fifth Circuit said that the standard error of measurement's not 3, it's 5. And so in that case, 4 out of the 5 scores that Mr. Smith had here would qualify him as being intellectually disabled under a standard that you agree with, correct?
So, Your Honor, the way in which these scores were analyzed below was not contested by Mr. Smith or his counsel. So I understand that you are referring to Black versus Carpenter. And in other circuits, including the Sixth Circuit, the Fifth Circuit, and the 10th Circuit, apply a very similar standard to the state of Alabama and have been upheld as constitutional.
Counselor, if a clinical diagnosis of intellectual disability depends on considering both IQ scores and adaptive functioning, why should a state be allowed to ignore the full range of evidence simply because a score is 71 and not 70?
So we're not suggesting that there should be a rigid cutoff of 71 versus 70. I think the state of Alabama accounted for the standard error of measurement in its own analysis, but you can't satisfy one prong of a conjunctive test by satisfying another prong. They are separate, independent requirements.
But at least 2 of the scores meet that threshold that you just referred to, right? So why not take into account the fact that the 2 scores that are closest in time to the offense at issue, and also the one that's closest in time to the developmental period, actually do bring the defendant below the 70 threshold when you take into account the standard of error? Why is that not sufficient?
Well, Your Honor, the lowest score actually was in 1998. It was a 72, and it was just during the proceedings, the capital murder proceedings.
Contemporaneous with the offense.
Correct. And the medical experts have established that higher IQ scores are actually more reliable because lower IQ scores can be lowered by temporal factors like fatigue or stress. And this really is made evident here in this case, where his lowest IQ score was taken at one of the most stressful periods of his life. But his IQ in 2014 was 78. In 2017, it was 74. In 1979, it was 75. In 1982, it was 74. It's remarkably consistent, and that's why the experts were comfortable with the confidence interval that I've discussed with this court.
Counselor, doesn't your interpretation of the statute require us to overturn Hall and Moore?
No, Your Honor. In fact, in Hall, this court took issue with Florida's rigid cutoff and the fact that it did not account for the standard error of measurement, which is exactly what the state of Alabama did.
But doesn't Hall stand for the proposition that this disability, or the disability that we're looking at, is a condition and not a number? And your whole dialogue today has been on the number. So how do you square that with Hall?
Well, so Justice Naftalis, I'm speaking of the first prong, and it's a conjunctive test, and it's a test that this court designed to assess whether individual defendants are eligible for exemption from capital punishment. It is a three-pronged test, so it is not about declining to view this as a condition. It's about looking at the standard and requiring defendants to meet their burden of proof in order to advantage themselves of the exemption from the death penalty.
Thank you, Ms. Jestin. We will now hear from you. Your time is up. We will now hear from you, Mr. Sahni.
Madam Chief Justice, and may it please the court, in 3 different cases over the last 11 years, this court has ruled that intellectual disability cannot turn on IQ scores alone, and that all relevant evidence must be considered in making that judgment. In Hall versus Florida, Brumfield v. Kane, and Moore versus Texas, this court recognized that intellectual disability is a condition, not a number, and that an IQ score is an approximation, not a final and infallible assessment of intellectual functioning. In this case, the lower court's holistic approach to multiple IQ scores that considered the relevant evidence in the record, including relevant expert testimony, was entirely consistent with this court's recent Eighth Amendment jurisprudence on intellectual disability. Following a detailed evidentiary hearing, the district court considered each of Mr. Smith's 5 IQ scores, both individually and cumulatively. It evaluated competing expert testimony about his IQ tests, including testimony that 4 of his 5 tests, when accounting for margins of error, were consistent with intellectual disability. The court also made findings as to significant deficits in Mr. Smith's adaptive functioning. These deficits manifested during Mr. Smith's developmental years, as evidenced by, among other things, his placement in classes for the intellectually disabled as early as 7th and 8th grade, his last years of any education. For over a quarter century, Mr. Smith has been in legal limbo, with the specter of the death penalty hanging over him. The lower court's finding that he is intellectually disabled should be affirmed, and his death sentence should be vacated with finality.
Mr.
I welcome
Sahni.
the court's questions.
Mr. Sahni, how do you square the burden of proof that your client had at the district court with the district court's finding that his scores, quote, did not foreclose the conclusion that he satisfied the first prong? That very language seems to shift the burden of proof so that the state has to disprove rather than your client having to prove.
Justice Weitzman, the district court was emphatically clear in its conclusion that, quote, Smith has shown by a preponderance of the evidence that he has significantly sub-average intellectual functioning and significant deficits in adaptive functioning, which were manifested during a developmental age. It is the case that the district court considered each of his IQ scores, but also considered evidence from the adaptive functioning prong in the context of making a judgment as to prong 1, whether he had requisite intellectual functioning. And in doing so, the district court's analysis was entirely consistent with what this court did in Hall and then again in Moore.
Counselor, in this case, if I believe Mr. Smith had 5 IQ scores that were all in the 70s. But let's take another hypothetical, one closer to the Fifth Circuit case, Garcia versus Stevens. In that case, I believe the defendant had an IQ score in the 70s and then 4 additional IQ scores that were between 83 and 100. So are you advocating what petitioner is calling this one low test rule, that whenever you have an IQ score where the low end of the range falls below 70, you have to treat the intellectual functioning prong as satisfied?
No, Justice Colson, we are not advocating that, and neither did the 11th Circuit after this court's initial or secondary remand. The 11th Circuit made clear that it was not relying or creating a rule that the lowest test, and in this case, because with the standard error of measurement, it extended 69, satisfied prong 1. In fact, in the facts of Hall, in Hall, the defendant had 9 different IQ scores. 2 of them had been excluded for evidentiary reasons, and the remaining 7 were all above 70. But nevertheless, this court, in an opinion by Justice Kennedy, made clear that IQ scores alone are not dispositive. And evidence that related to the standard error of measurement, the testing conditions, the time frame of the IQ tests, and other evidence had to be considered because ultimately, as this court made clear in Hall, the test under prongs 1 and 2 is conjunctive and interrelated, which is to say that more than just IQ tests have to be considered in a court's holistic analysis of intellectual functioning.
Don't multiple IQ tests give courts a much better sense of someone's true IQ, especially, as you say, over a long period of time? There's no requirement that we only follow the lowest score.
They might in certain cases, Justice Garagos. In this case, the crowding of the IQ scores in the 70s, and with a 95% confidence level, if you exclude the highest one of 78 and use a plus or minus 5, then the range is 65 to 75. In certain cases, there may be IQ scores which are of a sufficient degree and conclusively establish that a defendant is not intellectually disabled. But in Hall, this court made clear that because the test itself may be flawed or administered in a consistently flawed manner, multiple examinations may nevertheless result in repeated similar scores, so that even a consistent score is not conclusive evidence of intellectual functioning.
Mr. Sahni, you've argued in your papers that this court should not adopt a bright line rule, but it's our job to give meaningful guidance to lower courts. So what framework should lower courts apply?
Justice Imperator, this court's framework coming out of Atkins versus Virginia in 3 recent Eighth Amendment cases involving intellectual disability provide exactly the framework that lower courts can apply and that the district court applied in this case when conducting an evidentiary hearing. We take no issue with the state of Alabama's reference to its statute in this case, but all that statute provides is that the burden of proof rests on the defendant by a preponderance of the evidence. Nothing more and nothing less. The state of Alabama's legislative scheme, which it's entitled to create subsequent to Atkins and implement a procedural framework for making sure these decisions are compliant with the Eighth Amendment, does not foreclose the consideration of multiple IQ scores or evidence of adaptive dysfunction in a judgment as to whether prong 1 of sub-average intellectual function has been satisfied. This court's 3 recent decisions over the last decade provide the ample framework that district courts and state courts have been applying for years and years.
Counselor, you're asking us to treat any score that's close to 70 as potentially indicative of intellectual disability. Where does that end? What's your limiting principle?
Your Honor, Mr. Smith's position is not that any score close to 70 means he's intellectually disabled. In fact, in this case, the district court considered all 5 of his IQ scores, considered the testing conditions he was under, then also considered testimony related to his childhood, his behavioral characteristics, and based on the consideration of that totality of the circumstances, concluded that he had satisfied the first prong of Atkins, an intellectual deficit that was significant and sub-average.
So, I mean, is the first prong just meaningless? Like, we just go right to the second prong here?
Not at all, Your Honor. The first prong of, there may be any number of instances in which the evidence that is adduced for one prong may be relevant to another prong. So, for example, if in consideration of adaptive functioning, where a court's supposed to consider everyday practical skills, a defendant, an expert testifies that a defendant wasn't able to tie his shoes or wasn't able to transport himself. The reasons why that defendant may lack that ability to do so may very well be probative both of adaptive deficits and intellectual deficits, as was the case here. The evidence that Mr. Smith adduced through the testimony of Dr. Fabian, a neuropsychologist, pointed to his struggle for recall, his weak word knowledge and usage, his emotional personality dysfunction, and his inability to deal with everyday stresses.
But how do we get to that if the claimant here, your client, doesn't meet the threshold on the IQ tests? 4 out of the 5 tests don't qualify. It seems like we're somewhat being asked to rewrite Alabama law, and I do take note of your opponent's argument that Alabama and its law and its wisdom is being questioned. Why shouldn't we trust the states to determine the appropriate community standards for their communities, regardless of whether we believe them personally or not?
Justice O, following Atkins, the states are entitled to create the procedures and parameters by which courts informed by the medical community are to assess intellectual disability. But
Counselor, if this court keeps on defining medical criteria, are we just turning constitutional law into a psychology manual? I mean, how are courts supposed to figure this out?
No, Your Honor. In every case since Atkins, this court has cited to the APA and the AAIID as relevant medical authorities to inform its judgments of what is considered an intellectual disability, just as it has in the context of making insanity judgments. And it was exactly for those reasons that in Hall, the court concluded that relevant medical and clinical authorities all agree that an individual with an IQ above 70 may still be properly diagnosed with an intellectual disability if significant limitations in adaptive functioning exist, as the district court and 11th Circuit found
Counselor,
here.
at what point is the IQ score high enough that it becomes dispositive on its own?
Your Honor, there's no bright line rule in this court's Eighth Amendment jurisprudence, but there very well may be instances and fact patterns where IQ scores that are far from 70 over a long period of time, in the absence of evidence of adaptive deficits, could suffice to satisfy prong 1.
So we are always required to consider adaptive deficits even if the score is 90 or 95?
No, there may be many instances in which a court may make that judgment just on the basis of IQ scores if it does so holistically, if it considers the standard error of measurements, the test conditions, the timing of the test, the relationship between IQ test scores. In this case, the district court did all of that and found that it was a close enough question that the IQ scores alone did not resolve prong 1, and that's why it turned to evidence beyond prong 1, including evidence about adaptive deficits and dysfunction.
Mr. Sahni, and I have to say I've been waiting for this moment for quite some time.
I don't know what to make of that, Justice Naftalis.
Mr. Sahni, if the experts on the one side numerically say there's no issue, but on the qualitative side say there is an issue, how does a judge resolve that? Is it a coin flip?
No, Justice Naftalis. In this case, the district court was not confident on an evaluation or assessment based solely on the IQ scores alone. The district court heard from 3 different experts. One, Dr. Chudy, who is the expert at sentencing, and then Dr. King, who is the state's expert, and Dr. Fabian, who is Smith's expert. The district court made credibility findings and concluded that Dr. King, the state's expert, was not compelling. And these are the kinds of factual assessments and judgments that fact finders in district courts and state courts all around the country make every day with good reason. And there is nothing under Alabama law that precludes a court or a fact finder from considering those sorts of factors, from considering that kind of evidence beyond just IQ scores.
Mr. Sahni, I know we've affirmed Atkins a number of times, but I want to push on that. The Supreme Court in the past 15 years has increasingly relied on historical tests, and I can't think of another rule of a constitutional proportion that says every state can decide for themselves and there could be a national consensus that changes year to year or decade to decade. And that's essentially what Atkins said. One time there could be a national consensus that 70 is the proper cutoff or reflective of incapacity, and another in 10 or 20 years, the medical community may say it's 80 or 90. Why should we subject constitutional norms to the whims of state legislatures and a national consensus in that regard?
Justice Weitzman, in Atkins, the court made clear that the Eighth Amendment, as it has even since Penry, turns on evolving standards of decency. And that necessarily requires an assessment of consensus. And since Atkins, in the Eighth Amendment context, courts have typically looked towards what have state legislatures done. And as of this moment, the only state legislature that has a hard and fast cutoff on IQ scores is Oklahoma, which says that if you have an IQ score of 76, then you need not look any further. But there has been a national consensus among state legislatures by inference, since no other state, with the exception of Oklahoma, has implemented that kind of rigid categorical statute. And this court's cases have repeatedly made clear that the sort of national consensus that ought to be considered starts first and foremost with what state legislatures do, and then looking towards what do state courts do? How do they interpret how state legislatures are constructing parameters around a judgment of intellectual dysfunction? And that has been the framework that this court has used since the Penry decision, which predated Atkins by 10 years. And in all of the subsequent Eighth Amendment cases on the consideration of intellectual dysfunction since Atkins has reaffirmed the reliance on ascertaining what national consensus exists. And in this case, there is an absence of any consensus that would take the sort of categorical rule that the state of Alabama proposes here. Barring any other questions from this panel, we will rest on our papers. Thank you, Your Honor.
Thank you, Mr. Sahni. Ms. Jestin, you have 5 minutes for rebuttal.
Thank you. Respectfully, the respondent seeks to rewrite Alabama law. Nothing in this court's Eighth Amendment jurisprudence requires a holistic balancing test. That is not what Atkins versus Virginia requires, and that is not what Hall requires. That is not what Moore requires. This court's jurisprudence supports the approach of the state of Alabama that has constructed a carefully calibrated statutory scheme under which defendants must establish their entitlement to Atkins relief.
But aren't you asking us to retreat from Hall and Moore?
No, Your Honor, that is an overreading of Hall and Moore, respectfully. Neither Hall nor Moore created a burden-shifting mechanism, and the state of Alabama requires the defendant to meet the burden by a preponderance of the evidence in this case found that Mr. Smith did not meet that burden. Neither Hall nor Moore eviscerates the approach of the state. Instead, the 11th Circuit tries to rewrite Alabama law and interferes with state sovereignty and principles of federalism, and this court should not countenance it.
Ms. Jestin, why is this not just a question of deference to district court decision-making after an evidentiary hearing with experts? We're hearing a lot about the 11th Circuit questioning Alabama law, but isn't this simply a question of deference to the district court?
Your Honor, the 11th Circuit inverted the burden required by the state of Alabama. The state of Alabama found that Mr. Smith was not entitled to Atkins relief. The court in Hall required the consideration of margins of error, not ignoring their implications when they don't favor the defendant. Respectfully, the respondent is conflating the requirement to consider evidence with the satisfaction of legal standards, and the 11th Circuit's decision should be vacated.
So the respondent says that the state of Alabama is the one that's actually shifting the burden of proof by requiring individuals with borderline IQs to disprove the possibility that their true IQ score exceeds 70. So how would you respond to that?
I don't think anything in the record suggests that Mr. Smith has a borderline IQ. They analyzed 5 IQ scores over the span of 4 decades. This is not a situation, as we saw in Hall versus Florida, where the state had a rigid cutoff, and someone with an IQ of 71 would not be eligible for Atkins relief because it did not.
Counselor, isn't that exactly what you're asking us to say? You've said that the average was 72, it's above 70, and therefore we need to reverse the lower court's decision.
No, Your Honor, because in Alabama, they did incorporate the standard error of measurement margin of error in their analysis, whereas in Hall versus Florida, the state did not. And that was the court's criticism of Florida law. And Alabama did exactly what this court said it should do in Hall versus Florida.
How do you respond to respondents' argument that intellectual disability is a qualitative assessment and not one that's rooted in IQ scores?
I think that the test set forth in Atkins versus Virginia will account for that, Your Honor. It is a 3-pronged test that looks at 3 different constituents to determine whether somebody is eligible for Atkins relief. But each prong is an independent requirement that has to be satisfied by a preponderance of the evidence.
But nothing in Atkins, Ms. Jestin, requires that the first prong be satisfied before any other prong is reviewed, right?
No, Your Honor, but you cannot.
And so it's Alabama's decision to have a cutoff, but Atkins does not require that, right?
That's correct, Your Honor. Okay. That is correct. But you can't use proof that satisfies one element to satisfy another element. Each element has to be independently satisfied.
What if you're right on the nose? What if you're right at 70, taking into account all statistical calculations that none of us know how to do? Then what?
I think that would be a closer case, Your Honor, but that's not the case we have here. We will also rest on our papers if there's nothing further from it.
Thank you, Ms. Jestin. The case is submitted.
Please rise. The mock Supreme Court of the United States now stands adjourned. The court will reconvene on Monday, October 5th, 2026 at 10 a.m.
Okay, nobody leave yet. We're not done. Thank you for that. That was a fantastic argument. Let's get another round of applause for our brave advocates. You know, that was quite a heavy subject matter. So we'll try to lighten the mood a little bit now. And it is my honor to introduce the first winner of our Gould Award for Outstanding Oral Advocacy, Katya Jestin. As a bit of a surprise to me, it turned out not to be very easy to come up with the remarks I was going to make tonight for Katya. And it's not because I don't know her. I mean, we have been great friends for something like 25 years. We live in the same neighborhood. Our children grew up together. Our spouses are friends. But that's kind of the problem. We're so close that I feel almost like she's a sister to me. And as we all know, we don't say nice things about our sister. We tease each other mercilessly. That's how it's supposed to work. I mean, we text each other or talk literally every day, usually, as part of our daily Wordle and connections competition. And the winner always mocks the loser. And believe it or not, she claims the reason why she almost never beats me at Wordle is because her vocabulary is so big that she can't narrow it down to the right words to choose. So I'm not sure how she's going to react tonight to hear me stand up in front of like every lawyer in the city that we know and actually say what a huge admirer I am of hers. She probably is expecting a roast, but what she's going to get is something very different. She is truly one of the finest lawyers and the finest people that I know. I first met her in 2001 in the Eastern District of New York, U.S. Attorney's Office. She had started a couple of months before me, which meant that forever she was, going to be senior to me in the office. And she was actually the first assistant U.S. attorney I watched as a new assistant in the office, and I went to the courthouse to observe a few people. I was a brand new, terrified prosecutor, and I watched with amazement as she cross-examined a defendant in her first trial and was unflappable in the face of repeated, really crazy objections meant mostly to throw her off her game and a hostile judge, and she bore it all with incredible grace and tenaciousness. And as we progressed in the office, she outwardly demonstrated that same fearlessness all the time, taking on difficult cases and standing up to bullies. When we were outside of the office and back in our offices, like the rest of us, she had the same anxieties and self-doubt. But when the lights were on, so was she. She was self-assured, poised, and determined, just as we saw her. She's great in front of a jury. She's smart, she's strategic, and she has unerring judgment in which arguments will land and which ones won't. But more than all of her skills as a lawyer, she has always shown tremendous empathy, even for the people that she prosecuted, and a commitment to making sure that justice was always meted out with humanity. I saw her go to bat for defendants with her supervisors on countless occasions, arguing for compromises on charges and sentences when the facts and the law called for it, instead of always pushing for the maximalist government position. And when defendants came in and proffered or became cooperating witnesses, she treated them kindly and empathetically and saw the goodness in them, notwithstanding whatever they'd been charged with. And she did all this with no hint of ego. Katya is, I think it's fair to say, unimpressed by people who take themselves too seriously. She herself is self-deprecating, even to a fault, mostly because, like all real leaders, she's entirely focused on getting the best result, not on who gets the most credit for it. So it's no surprise to me that she has been an extraordinary success as a defense attorney and leader in private practice. She's been at Jenner & Block for more than 18 years. She recently stepped down after a 5-year term as the co-managing partner of the firm. And the work that she has done for some of the most prominent white-collar defendants and companies is well known, but I would rather focus on the work that she and her firm have done for those who couldn't otherwise afford to hire a law firm like Jenner & Block. Jenner is known as perhaps the premier pro bono private law firm in the country. The firm has earned the #1 pro bono ranking from the American Lawyer an incredible 13 times and was recently ranked in the top 5 on the prestigious A-list, which balances both paid client work and pro bono work. Katya has served selflessly on OAD's board for many years, has been a huge supporter of our organization and our efforts, and her own individual pro bono practice is legendary and included representing Guantanamo detainee Majid Khan for more than a decade, while already managing an incredibly busy paying client practice. Katya found time to make the arduous trip to Guantanamo countless times to meet with Mr. Khan. And her efforts resulted in his release and resettlement in Belize in February 2023. In fact, he was the first high-value detainee to be transferred out of Guantanamo. And I would ask her when she would, complain about the difficult legs of the trip to get down to Guantanamo, and I would say to her, why do you spend so much time on this case? And she would answer simply, because it's the right thing to do. What the government is doing is wrong. Under Katya's leadership, Jenner & Block continues to be a firm that does the right thing and stands up to the government when what it is doing is wrong. Katya has been a devoted and considerate mentor and has trained an entire generation of Jenner and Block associates in how to be excellent lawyers with humanity and integrity. I could go on, but we promised we would stay on schedule, and I'm not sure how much longer Katya can handle hearing me say nice things about her. So in recognition of her exceptional professionalism, her leadership, her advocacy, it is my extraordinary pleasure to present the Milton S. Gould Award for Outstanding Oral Advocacy to OAD board member and my great friend, Katya Jestin.
Thank you, Nick. That was very nice. It was very awkward. Thank you. So first, I want to thank the Office of the Appellate Defender for this tremendous honor. I can't think of a time in recent history when OAD's mission has been more important. The inequities in our criminal legal system and in our society at large are ever more stark. And the commitment of folks at OAD to providing superlative post-conviction and appellate representation to those who cannot afford it is what we are here to honor and support tonight. To me, this event is an annual hallmark of our commitment, our collective commitment to the pursuit of more equity and access to justice and the rule of law. We get together every year, we raise money for this incredibly important organization. And today, that commitment requires a greater measure of moral courage than ever before. We are standing together as lawyers in a moment in history where I think it is fair to say that we are all bearing witness or experiencing firsthand concrete challenges to the ideals of our profession and to democracy itself. Challenges that none of us, I reckon, have encountered before in our lifetime. Each of us as lawyers has an obligation and a privilege to double down our commitment to this profession and to our guardianship of the rule of law. And this is the time for each and one of us to summon the courage to stand up and fight. To not only fight for the indigent and provide more equal access to quality counsel like OAD, but to fight for what is right and just in our profession as a whole. I want to congratulate my fellow awardees to Freshfields for all of your terrific work, to Dexter Murray and the inspiration, my friend, you bring, to my good friend Anjan Sahni and opponent, managing partner of Wilmer Hale, a firm that stood up and is fighting this administration, to Cari Gallman, each for their well-deserved honors, and I thank you to the incredible bench. I know how much work it takes to get ready for this evening. And for my part, I'm so grateful for this award from an organization that I so deeply admire, and I'm so privileged to be on the board of this organization, and I'm deeply thankful to Caprice Jennerson for your incredible leadership. Thank you. And to the remarkable talent at OAD. It truly is a remarkable organization, best in class, that provides such incredible range of service to its clients. I thank Nick, my good friend, who's just humiliated me for a good 10 minutes, it felt like, but thank you. And thank you for all you do in service of this organization as its board chair. And finally, I want to acknowledge my entire family who are here this evening, ever supportive. I really appreciate it. And I'm very especially thankful to my 17-year-old twins, Maddie and James, who are here on a school night, who suffered through this whole thing. And you're the reason I have hope, and I love you. Thank you very much.
So I just want to have everyone give a hand to our bench, because this was really an epic bench, one of the best benches that I've heard in my time on the board of the OAD. So let's just give a hand. And I want to start out, before I introduce Anjan, I want to start out by saying that I was given explicit instructions to not focus on Anjan's time as a federal prosecutor, because we're all here to talk about the defense role, right? And here I am, an alumna of the mighty Southern District of New York, with Anjan Sahni, who is a generational prosecutor in the Southern District of New York. And I've been bested here by Nick Borton and these Eastern District, you know, getting in Katya's time in the office, which I'm sure was fantastic, but Anjan's was as well. I'm gonna leap over all of that, no more of that tonight. But suffice to say, on another occasion, any of us could talk about Anjan's enormous contributions in his life when he was in government. But tonight we're here to honor Anjan. I'm here to introduce him. The Milton Gould Award for Outstanding Oral Advocacy, as you've heard, is presented annually by the OAD to two of the nation's most highly regarded advocates, recognizing their exceptional oral advocacy and commitment to justice. And on behalf of the OAD, it's really my pleasure to introduce Anjan. Here are some things that you may already know about Anjan. He's older than many of you, but he's very young. He's 49 years old. Anjan moved to the United States when he was 9. He grew up in Atlanta, and he moved to New York shortly before the attacks of September 11th, 2001. Anjan is the managing partner of one of the best law firms in the United States and one of our great national institutions, WilmerHale. In that role, he was called upon this year, a very young man in the scheme of things, to lead his firm, a firm of 1,000 lawyers and probably as many staff, when it came under attack by the President of the United States. Anjan is a graduate of Emory University and the Yale Law School. He was a federal prosecutor, as I mentioned, early in his career, but no more of that. And he has been doing justice on the defense side for nearly 15 years. When asked by a reporter recently about some of the more memorable cases he's had as a defense lawyer, Anjan answered, "One of my most meaningful cases was representing someone who is now a friend of mine, Rohan Ramchandani, who was a trader at Citibank, who had been charged with criminal antitrust violations." These are Anjan's words. "He was a man of great integrity and courage. He waived extradition from England, and he came to the United States to stand trial, to face charges that he and I, his lawyer, felt very strongly about his innocence with regard to. He went to trial, and with Anjan at his side, this man was acquitted." As Anjan told the reporter at the time, "This was the first case I'd had on the defense side, and the responsibility of defending someone in that circumstance who felt so strongly about his innocence and should never have been charged in the first place was so meaningful to me." What you may also know about Anjan is that he does legal work for the Sikh Coalition, an organization founded by volunteers on the night of September 11th, 2001, in response to a torrent of violent attacks against Sikh Americans across the United States. Anjan represents indigent Sikhs charged with criminal offenses, and he represents Sikh victims of hate crimes. Anjan is an extraordinarily talented lawyer. In my view, he's a generational talent. Among his many honors and awards, and I'm just going to read a couple of them, he was named a 2022 Rainmaker by Minority Corporate Counsel Association in this country. He's been selected by his peers for inclusion in the 2021 through 2024 editions of the Best Lawyers in America. He was named a 2022 Notable Diverse Leader in Law by Crain's New York Business. He's been named to the Lawyers of Color Power List 2020, a list of influential minority attorneys in the United States, and the list goes on and on. I'd like to highlight now a few things that you may not know about Anjan. Among his partners, he's known for his, and I'm quoting, "his kindness, his wisdom, and his strength." Again, another quote from his partners, "Anjan brings out the best in people. His primary gift is his ability to communicate with his partners, with judges, with adversaries, with clients, literally with any audience." And I think we've all been treated here this evening to bear witness to that. But there are still some things Anjan cannot do, according to his partners. Apparently, he has trouble dressing. He manages one of the preeminent corporate law firms in the United States, but seems not to own a pair of shoes without holes. The matching of jackets and trousers apparently is not a foregone conclusion for Anjan. He has trouble remembering to eat regularly and what he should eat. I'm told that Anjan can go for days at a time just kind of eating candy. He spends a lot of time, too much of his life, in traffic. Anjan decided with his wife, Rena, to live in Cobble Hill. You know, who among us would not? It's beautiful there. But they decided to enroll their daughters, Annika and Laika, about as far up the Upper East Side as a person could find. And so apparently Anjan is generally like in his car all weekend long, commuting from one of his daughter's events to another. Anjan, you don't have to spend every weekend commuting up and down the island of Manhattan. There are basic life management skills that your partners will be glad to help you with. Now that you're done studying for your first Monday argument, I'm sure we can find time to help you. On a personal note, for me, it's a pleasure to introduce you, Anjan. I'm sure what I'm about to describe you have no memory of, and Mark Berger, who may be here, I think I saw him, may have no memory of. But when Anjan was chief of the securities fraud unit, this would have been in about 2012. Maybe he was co-chief with Mark, I think. Anjan, you were the first audience that I faced as a defense lawyer in my career trying to persuade the office not to indict an innocent client. This was in a very high-profile insider trading case that did proceed to trial without my client. Other defendants were convicted after trial and ultimately exonerated in the Second Circuit. Anjan, I don't remember your wardrobe, and I'm pretty sure you didn't give me any candy, but you were kind, and you were fair, and you were wise in that meeting, and you made the right call, and the office did the right thing. See, I did bring it back to the office, Nick, and it's my great pleasure and honor to offer you this well-deserved honor tonight. Thank you very much.
Thank you, Joanna, for that extraordinarily kind introduction. And thank you to OAD for this honor. I've come to this event a number of times over the years and seen legends of the defense bar present very memorable oral arguments, and I feel deeply unworthy to be in their company. Congratulations to my friend Katya. It's been a lot of fun to get to do this event with you. Katya lives a few blocks from me in Brooklyn, and we periodically get together for coffee in the neighborhood. It usually consists of me seeking her wise counsel and advice. A couple of years ago, she warned me about taking on the role of managing a big law firm, and I brushed off her admonition and thought, what's the big deal? How stressful could this be? It's not like Wilmer and Jenner are going to be the target of any future administration. There are a number of people here I'd like to thank for attending. A great many friends and former colleagues from the U.S. Attorney's Office and from the defense bar, a number of whom are on the bench. My dear colleagues from WilmerHale, thank you for coming. You are terrific lawyers and even better friends, and you make it a joy to go to the office somewhere between 2 and 3 days a week. I want to recognize my wife and children, My wife, Rena, remains the single wisest lawyer and source of counsel whom I know. Her patience and remarkable sense of calm anchor our family. Our two daughters, Annika and Leica, I tried to explain to them what this case was about so they could follow along. The only direction that Leica had for me was, don't embarrass me. Both of them are fiery, irreverent, kind, and very funny young people, and Rena and I couldn't be prouder of them. I'd also like to recognize my parents and sister in Atlanta who couldn't be here. I owe them a huge debt of gratitude for taking the risk of immigrating to this country 40 years ago. Last night, my mom texted me to send their best wishes and to share some very important last-minute advice. She wrote, and this is a literal quote, "You may want to wear a maroon turban. It will look regal." I did not do that. I'm enormously grateful to my parents for their sacrifices. In October of 1984, India's Prime Minister, Indira Gandhi, was assassinated by two of her bodyguards who were Sikh men. And in the aftermath of her death, several of India's major cities were engulfed by horrific violence against Sikhs in retaliation for Gandhi's murder. For several days, the military and the police stood by idly as vengeful mobs attacked and killed thousands of Sikhs. In some cases, the police and military even facilitated and condoned the targeting of Sikhs. My family and I were lucky to emerge safely from that dark episode in Indian history. And 9 months later, in July of 1985, we left New Delhi and moved to this country, initially to New York, and then to Atlanta. Although now several decades ago, the Sikh riots of 1984 have always been a reminder to me of what can happen when a nation's commitment to the rule of law weakens, when government institutions abdicate their most basic civic responsibilities, and when retribution and vengeance supplant justice. Lastly, I do want to take a moment to thank the OAD, whose mission is to protect the rule of law and to promote fair and equal access to justice. That mission, as Katya said, is more critical than ever. Caprice, we are all inspired to hear what you and your team accomplish every day in the world of indigent defense and criminal justice reform. And Mr. Murray, thank you for sharing your testimonial as well, which was very powerful. You and your colleagues play a very important part in ensuring that the government acts lawfully, fairly, and justly. Thank you for your leadership, for your powerful voice, and for energizing this legal community to support this very impactful institution. Thank you all for being here, for supporting OAD, and for this extremely meaningful honor.
Good evening. My name is David Gopstein. I'm a proud OAD board member, and it is my great pleasure to introduce tonight's final honoree, Cari Gallman. When not leading the Supreme Court as our Chief Justice, Cari's day job is serving as Executive Vice President, General Counsel, and Chief Policy Officer at Bristol-Myers Squibb. I've known Cari for over 20 years. We went to college together. We were in the same summer associate class at Debevoise, along with OAD supervising attorney Sean Nuttall, who's here today, along with his mother. Hello. And we spent our first several years together as associates at Debevoise. And from the very beginning, Cari stood out, not just because she was obviously an extraordinary lawyer, but because she had a combination of compassion, charisma, and humor that inspired the people around her and drew them towards her. Everyone at every level wanted to work with Cari. It was something I heard over and over again for almost 7 years. So it was no surprise to anyone who knew her back then to see Cari's meteoric rise at BMS. She joined the company 10 years ago and has held numerous increasingly senior positions, including as the company's Chief Compliance and Ethics Officer and as its Head of Corporate Affairs. These were roles that reflected not just her skill as a lawyer, but also as a leader. And the thing about Cari is that while she has risen through the ranks to the senior-most levels of BMS, she has maintained the same humanity and humility that made people gravitate towards her years ago. And it's something that comes through as soon as you start speaking with her. You can feel it. I'm personally excited to see all that she is going to do in the years to come in her current role. And I have no doubt that many people will be the better for it, not just within BMS, but more broadly. Because when someone like Cari is at the helm of a company with a mission like that of BMS, good things happen. I could say a lot more about Cari, but I was instructed to stop at 2 minutes, and that if I didn't, the Supreme Court may not give its decision this evening. And so I'll conclude just by thanking Cari for participating tonight, for your support of OAD, and I'm very proud to present you with this year's Council of Justice Award.
Well, we have some deliberating to do, so I will be intentionally brief. First, thank you, David. I cannot believe it's been more than 20 years since we first met. And one just very brief true story. So it is true, I got to work on a lot of amazing cases when I was at Debevoise. The one company for whom I really wanted to have a case was BMS. And when they had a chance to staff it, they staffed David. It worked out, but you should just know that that was a moment for me. But anyway, thank you, and thank you for those incredibly kind remarks. And really, thank you to the Office of the Appellate Defender for this recognition. Serving as the Chief Justice for this mock argument and preparing for it was delightful. It was equal parts adrenaline, legalese, and it really did afford me the opportunity to delve into legal nerddom in a way I don't often get to do anymore, and so I loved it. But more importantly, it actually reminded me of the work that you all do every day, and frankly, the reason why the OAD exists, which is you turn chaos into clear, not that tall, clear precedent. You make mercy from the misunderstood record, and you undo the unjust. And so it is an incredible honor for me to be recognized by an organization that I respect and admire so much. An organization who, as has been referenced so many times, whose mission is rooted in justice and in the unwavering defense, frankly, more than just justice, but of human dignity. And so the work that you do is not just important. I know you know this, but it needs to be said. It is essential. In a system that too often overlooks the vulnerable, and especially right now, you all stand as the pillar and one of the true pillars of hope. Your attorneys fight tirelessly to ensure that every person, regardless of their background or circumstance, receives the fair representation that they deserve, often at the moment when they're most forgotten and probably most helpless. And you remind us that justice is not just a privilege for the few, but a right for all. And your advocacy, I know you all know this, but your advocacy goes outside the courtroom. You invest in your clients as people and not just as cases, and your work matters because it changes lives. But even more than changing lives, it holds the system accountable. In my role as GC and Chief Policy Officer at BMS, we are a company that is committed to transforming patients' lives through science. And in that regard, I share your commitment and accountability to changing people's lives. As part of our mission, we seek to actively improve the health of the communities where we work and live and serve. And we make medicines, we're incredibly proud of this, we make medicines to help people at their most vulnerable, when they're fighting cancer, when they're recovering from stroke, when they're living with schizophrenia. And at first glance, our work may seem worlds apart, but at their core, I think they're both rooted in the same belief, which is that certain rights are fundamental and they must be protected steadfastly. And at this moment, when it feels like some of those core tenets that we all normally hold so dear and so steadfast, belief in science, belief in justice, are under attack, It is a tribute to the values that we share, and a really powerful reminder to me being here tonight and hearing these incredible speakers that justice requires persistence and partnership and purpose. And so I just want to thank the OAD for all that you do, your persistence, your partnership, and your purpose. Because I'm reminded being here tonight that systems or processes, even when they feel stacked against us, even in that moment, justice and human rights are not confined to any one sector or industry, but they are really shared pursuits for all of us. So I accept this award with immense gratitude, yes, for the recognition, but more for the incredible work of many of the people in this room, both the OAD, my co-honorees. Hearing all of the work that you do has just been amazing, and watching you argue, that was astonishing. And also, you know, with renewed dedication to ensuring that our work continues to uplift lives and restore hope. So thank you again. Thank you to Mr. Murray for your incredible words. That was inspiring. Thank you to my family. I would be remiss. They traveled in from New Jersey on a school night and are incredibly supportive. So thank you all for being here. Thank you for my BMS team for being here. For those of you from New York, you know, New Yorkers don't go to New Jersey. Getting New Jerseyites to New York is an equally challenging thing to do. So thank you all for being here. And now we have to get back to our deliberations. So thanks.
If you all could remain seated, just bear with us just a little bit longer. We'll listen in on the court's deliberations.
Okay. May I now have your decisions? Let's begin with Hamm v. Smith. Avi, we'll start with you.
I would rule in favor of the respondent. I was persuaded that the burden of proof was not shifted, and that the constitutional rules in Atkins and its progeny require an evaluation of the evidence in order to ensure that on a qualitative level, a offender who's incapacitated is not executed.
Benjamin?
I would also affirm. I think it's clear that the Eighth Circuit requires a holistic, Eighth Amendment requires a holistic, medically informed approach to determining disability, that IQ tests are inherently imprecise, and that ranges should be, and that they should be interpreted as ranges and not fixed numbers, and that the position that Alabama would put us in, were we to return to their rigid formalistic rules, would require a rejection of Hall and Moore, and would create the unacceptable risk of executing individuals whom the Eighth Amendment is meant to protect.
The script gives me first names. I'm going to switch back to justices because this is too much fun to switch out of just yet. Justice Massey.
I thought Katya did a great job with a weak hand. Anjan, nice job also. I would vote to affirm. I think it's just a classic case of affirming a district court's discretion after an evidentiary hearing.
Justice Levin.
Well, first I want to thank counsel for excellent advocacy, but I would affirm as well. So the district court's holistic assessment of multiple IQ scores and adaptive functioning evidence, in my opinion, align with established precedent and constitutional requirements, and denying relief on the basis of a mechanical cutoff does not prevent burden shifting, but rather introduces precisely the arbitrariness that the Eighth Amendment forbids. So I would affirm.
Thank you. Justice Imperator.
Despite the very powerful argument of Ms. Jestin, I also vote to affirm. I conclude that the Supreme Court precedent makes clear that when the standard of error of measurement of an IQ suggests that the true IQ may be less than or equal to 70, he should be able to present additional evidence. I find that intellectual disability is a qualitative rather than a quantitative assessment, And in this case, the district court carefully considered and balanced the full range of evidence, including expert testimony, and those findings are entitled to deference.
Justice Howe?
So first off, nevertheless, happy there was not an IQ test to get on the panel. Fake panel or not, I would have definitely needed the average. So you know where I'm going with this. In any event, like my fake predecessor on the Supreme Court, Justice Blackmun said, I do not wish to tinker with the machinery of death, nor do I believe in cold arithmetic of IQ scores, SEM adjustments notwithstanding. We're not governed by AI, or we're not Minority Report yet. There are no precogs in the tub telling us what the right answer is. We're human beings, we're frail, and we should be judged in our totality. We're more than the sum of our LSAT scores, or in the case of what Mr. Murray told us tonight, the sum of our criminal history. We're human beings, frailty and all, and we should be judged in our totality. I would affirm.
Justice Garagos.
Ms. Jestin, to quote your words, what the government was doing here was wrong. So I would vote to affirm. I think that the holistic approach that the 11th Circuit and the district court took was exactly what we wanted. The district court did exactly what we wanted it to do. It heard credible evidence, it weighed it, and their finding was in keeping with the precedent. So great arguments on both sides. It was an honor to be the justice, an associate justice presiding over this, so thank you.
Justice Colson.
Thank you. Finally, it's way past my bedtime, so. Katya and Anjan, congratulations. You both did a really fantastic job. It's no surprise, I think, that I also vote to affirm. I think IQ scores can be informative, but the medical community recognizes that they are imprecise and that they don't tell the whole story, and pretending that they do while sidelining everything else courts might learn about a person's intellectual and adaptive capacities really, in my view, puts too much weight on too thin a reed, especially when a human life is at stake.
Thank you. I would also vote to affirm for all the reasons that my colleagues have stated, as well as to make the other decision would require us to overturn both a district court ruling, the 11th Circuit ruling, and I am not convinced we would not have to set aside Hall and Moore. And for those reasons, I vote to affirm. Therefore, by a 9-0, despite the incredible arguments, by the way, put forward, by a 9-0 decision, we have affirmed the 11th Circuit decision, and I, because it is unanimous, am assigned the task of circulating and drafting the memo. Thank you.
So we did as we promised. It's not even 9 o'clock. So we hope that we will see all of you next year, October 5th, 2026, right here for the 33rd annual First Monday in October. Have a great night. Thank you.
That was good.
Pull the chairs back.